Chair, and thank you, ministers and witnesses, for being here. You know, I've been here as well all this time. I've studied as much information as I can on this committee and outside of this committee on the invocation. I still believe more strongly today than I did in 2022 that the circumstances to invoke the act were not met. The threshold was not met. And in fact, I agree with Justice Mosley on his decision that it was in fact illegal and unconstitutional. That is a binding precedent, unlike Rouleau's particular ruling. Now, the other thing that I think the Canadian public need to understand is Canadians expect of their government to follow the law, the rule of law, and not create an interpretation thereof that is convenient for the government to circumvent the existing law. And, you know, Mr. Brownie, you had indicated that, you know, there are hundreds of years of precedent for lawyer-client privilege. And, you know, the relationship has lasted hundreds of years. You know what else has lasted all that time? For Parliament to make laws of the land which govern the people. And by invoking the Emergencies Act, the Cabinet gave itself the power to pass criminal laws which Mosley found to be unconstitutional. Now my question to you is, have you actually found and read the infamous broader interpretation? Yes or no? Have you actually read the legal opinion, the broader interpretation that the government was telling everyone that they relied upon to invoke the Emergencies Act? Yes or no?
Mr. MOTZ, I'm trying to be helpful, but even answering that question would disclose social client privilege, which I cannot do here. But what I would say to you is that
let me stop you for a minute. You know, you obviously can you answer me the date stamp that was on that?
Mr. MOTZ, in terms of solicitor-client privilege.
Okay, so you can't. The reason I asked that question,
the questions you're asking me,
yes or no? Yeah, you already answered. It was a yes or no.
Interpretation.
Yes, it was a yes or no question.
Please don't talk over each other.
Mr. Browning, I don't believe for a second that the broader interpretation even existed when the Emergencies Act was invoked at the time of the invocation for a number of reasons. And, you know, it wasn't really until the, just weeks before the Rio Commission was about to begin that we all of a sudden heard about this broader interpretation, that it somehow magically appeared. And it's really quite disturbing that this broader interpretation is there now, and no one's seen it, no one's heard it, apparently. Mosley didn't get an opportunity to have it as part of his disposal, and neither did Justice Rouleau, who indicated that the evidence that he found to support the government's invocation was weak at best, and that anybody else could have come to a completely different conclusion. He was disappointed the government withheld that. So one of the questions that I've had for a long time is, who actually is the client? And you're hiding behind solicitor-client privilege. And why is it so difficult to, is it the government? Is it of Canada? Is it the governor and council? Is it the prime minister? Is it the attorney general? In your opinion, who is the actual client in solicitor-client privilege in this particular case?
In this particular case, the client is the government of Canada, and what I would say to you is the same thing I said to Senator Carignan, which is that there's nothing to hide, but there's everything to protect. And what my job is to protect basic principles about the administration of justice. Solicitor-client privilege is fundamental.